this next panel discussion. What should we call this, Ilan?
We haven't quite decided. I'm debating myself, I think, on the proposition.
Well, welcome to one of our final discussions. This discussion will turn on a question that lies at the center of many of today's legal battles. It's not simply what the courts should decide, but how they should decide it. As the judiciary continues to be the central battleground for challenges against the executive branch, critics have raised concerns that tools like nationwide injunctions and expansive theories of justiciability risk pushing the courts beyond their proper constitutional role. This panel will explore whether such trends threaten the constitutional structure and the long-term health of the judiciary itself, and can a return to judicial restraint and adherence to formalist doctrines preserve the court's legitimacy for another 250 years? To guide this conversation, we are fortunate to be joined by Judge Mark Holmes. Judge Holmes serves as a senior judge on the United States Tax Court, but before joining the bench, he practiced in Washington, D.C., in New York, and he served as the Deputy Assistant Attorney General in the Tax Division at the Department of Justice. But if you will indulge me for just a moment, I would like to offer a slightly more personal introduction for Judge Holmes. I have been a Judge Holmes fan longer than I have been a law student. Back in 2016, as a brand new CPA and tax associate at Ernst & Young, I was tasked with learning everything humanly possible about bad debt business deductions. A very glamorous assignment, I know. And after slogging through roughly 150 opinions on the subject, I set up an alert for new cases. And about a year later, in 2017, I got the alert for Judge Holmes' decision in Owens versus Commissioner. Now, when you hear tax law, your brain probably doesn't immediately think of puns or historic humor, but that is probably because you have never had the pleasure of reading a decision by Judge Mark Holmes. Sitting in my cubicle at almost midnight that night, I found myself chuckling aloud in a hauntingly empty office, and from that day on, I was a Judge Holmes superfan. So you can imagine my excitement when nearly a decade later, I discovered that Judge Holmes was a FedSoc speaker. And it only took me 2 years and the small effort of hosting the National Symposium to come up with an excuse to invite him to our chapter. And so without further ado, it is my honor to welcome the very first attendee that was invited to this event, the Honorable Judge Mark Van Dyke Holmes.
Thank you so much for that introduction, Morgan. I am one of two attendees, I think, who are both here today, and we're here at the first student symposium in 1982 at Yale. We have been debating matters of public policy and law ever since, and this was supposed to be a debate on the formalism and the fate of the republic defending the judiciary from itself, but we could find no one to debate Professor Wurman. He is so formidable a presence. That we kept upping the ante and finally tried to get people to debate him on the topic of, are federal district judges a threat to the republic? And still no one would disagree with Professor Wurman. So we are going to have a quasi-hemi-demi-semi debate here with Professor Ilan Wurman, well known to ASU. He used to teach here for a long time before he developed an unusual love of sub-freezing temperatures and moved to the University of Minnesota. He is a podcast host. Please listen to his podcast wherever you listen to your podcast. Rationally Based is the name of his podcast. And sign up for pre-publication copies of his new book, The Constitution of 1789, A New Interpretation. Professor Wurman is a graduate of Claremont McKenna College, where he majored in, get this, government and physics. Did you study with Charles Kessler, by the way?
I did.
Oh, a college classmate of mine. Then he went to Stanford Law School, clerked for the inestimable FedSoc member, Jerry Smith. He works in private practice to this day, so he is practically minded, as well as thinking about things like the spookiness of action at a distance. He is a longtime professor, as I said, at ASU Law School. His fields are administrative law and constitutional law. We are also very, very thankful to have his not quite debate opponent here tonight. He has promised to disagree with Professor Wurman but may not believe everything he says, which is good practice for lawyers and people who want to live in D.C. Professor Jonathan Green graduated from Northwestern, where he too had an unusual dual major of American Studies and German. He got his PhD in England at Cambridge on Edmund Burke's German reception, an incredibly fascinating subject to a handful of people. Then he went to Yale Law School, where he was a research assistant for William Eskridge, who is perhaps, even today, regarded as the leading living scholar of statutory interpretation. So I count on Professor Green to be able to take every side of every question of statutory interpretation. He also teaches at ASU, but he spent 2 years at America's foremost law school, the University of Chicago, my home school, teaching legal writing, I guess, as a Bigelow Fellow, as well as doing the research that gets you onto the faculty lists around America. His focus is on legal history, the history of constitutionalism, and theories of interpretation. So let's give them a round of applause, and then we'll let Professor Wurman go first.
Great. Well, thank you so much. Is this okay with the lapel? Okay. Closer. That's why I asked. All right, better? Okay. Well, thank you so much for having me here. Thanks to those of you who showed up to the live taping of that new podcast yesterday. The energy was great, the attendance was great, and the students on the panel were absolutely fantastic, so thank you for coming to that. One other preliminary note, as the judge said, this was supposed to be a debate. The proposition we had agreed on was district courts are a threat to the republic. I was going to argue in the affirmative. Instead, what I decided to do is I would talk about the general issue. I would be less polemical, and I would, try to give a more comprehensive picture of the issue. The only thing that I reserve is the right to use all of my opponent's time that he would have been here. I will go for, maybe a bit longer than you'd expect, 20, 25 minutes if I can swing in, and then I'm just very thankful that Professor Green has agreed to at least ask some questions and to be a bit of a gadfly. So the way I guess I want to address the question is, now that I don't have this debate opponent as such, is to reformulate the question, are we in a constitutional crisis? And if we are in a constitutional crisis, is it because of the disrespect that the president is showing the courts? Or is it because of a disrespect that the courts are showing the president? Or maybe it's a little bit of both, again, assuming there is a constitutional crisis to begin with. So I thought I would address this overarching proposition through a series of questions. The first question is it ever appropriate for the president to ignore a court order? And I'm going to argue, no, not merely if it's wrong on the merits. That is an insufficient reason to ignore a court order. But what if the court's so-called order was entered without jurisdiction? I'm going to argue that actually it would be appropriate for the president to ignore a so-called order, it wouldn't really be an order, entered without jurisdiction. But this creates something of a problem. What if the courts and the president disagree over whether the courts had jurisdiction? That, I want to suggest, would be a constitutional crisis if we came to that moment. There is no answer to that question, so I think it's important that cooler heads prevail if we come to such a situation. But in the smaller final part of my talk, I'd like to suggest that there are ways that courts can minimize the risk of such a conflict by more formalistically understanding what jurisdiction is and whether they have improperly been exercising jurisdiction. So I'm going to say a little bit about causes of action and a little bit about remedies and injunctions. Okay, so that's where this is going. Question number one, is it ever appropriate for the president to ignore a court order? Not because it's wrong on the merits. And here I want to draw your attention to the infamous Dred Scott case. Dred Scott against Sanford was wrong on the merits. What did Chief Justice Taney rule in Dred Scott against Sanford? He invalidated the Missouri Compromise, which more or less directly led to the coming of the Civil War, but he also held that free persons of African descent were not citizens of the United States and never could be citizens of the United States within the meaning of the Constitution, entitled to any of the privileges or immunities that the Constitution accords to its citizens. Was this decision wrong? Well, it was, according to Justice Benjamin Curtis and Abraham Lincoln, and they were right, so let me just explain to you the argument. Justice Curtis said free black persons were citizens of 5 states before the adoption of the Constitution. They were part of the people that participated in the public debate that led to the adoption and ratification of the Constitution. Nothing in the Constitution purports to strip them of citizenship. There's nothing in there, certainly, that directly or expressly says that. Congress has a naturalization power. That is the power to make new citizens of aliens. It is not the power to strip citizens of those who had it before the adoption of the Constitution or those who are natural-born citizens. And the natural-born citizenship requirement for presidential eligibility implies that their descendants would themselves be citizens of the United States. Chief Justice Taney and the court were basically dead wrong in the Dred Scott case. And so Lincoln argued that this case should be reversed, which led Judge Stephen Douglas in his debate, in his famous Lincoln-Douglas debates with Abraham Lincoln, to accuse Lincoln of defying the Supreme Court, of ignoring court orders. Lincoln, Douglas said, wants to reverse the Supreme Court's decision in the Dred Scott case. By which tribunal will Lincoln reverse it? To which tribunal will he appeal? Will he appeal to Lynch's law? Will he stir up strife and rebellion and the rule of the mob? It is enough for me, Judge Douglas said, to know that the Constitution has established the Supreme Court to definitively resolve all questions touching the true construction of the instrument, and its ruling is the supreme law of the land. This sounds like modern-day American might sound, actually. That's a conception that modern-day Americans often have about the courts. So what did Lincoln respond to this? He said, I think Dred Scott was wrong on the merits, but nobody is defying a judicial order. Nobody is purporting to disturb the judgment in that case. No mob is going to go and spring Dred Scott free from the clutches of his master, John Sandford. That decision, even though it's a Supreme Court decision, is binding on no one but Dred Scott and John Sandford. It is not binding in future cases. The Supreme Court has overturned its own decisions. We're going to seek to have it overturn this. But more than that, there were situations in which the question about free black citizenships might arise in the other government departments. Do they have to defer to Chief Justice Taney's erroneous ruling in the Dred Scott decision? So let me give you some examples. When Lincoln became president, he had to decide whether he could give coasting licenses and passports, which the statutes provided could only be given to citizens of the United States. Could he give them to free African Americans? So he had his Attorney General, Ed Bates, write an opinion, who basically said Chief Justice Taney was wrong, Justice Curtis was right, free black Americans are actually citizens within the meaning of the Constitution, and Lincoln granted them passports and coasting licenses. He did not treat the Supreme Court's pronouncement in a particular case as the supreme law of the land. What about Hiram Revels? Anybody know who Hiram Revels was? Good man. Thank you. There's at least one hand in the audience. Hiram Revels was the first African-American United States senator appointed by the reconstructed Mississippi legislature in 1870. What's the problem? Well, the Constitution says to be a senator of the United States, you must have been 9 years a citizen of the United States. Well, if Dred Scott was the supreme law of the land, then Hiram Revels had not been a citizen until 1868 with the adoption of the 14th Amendment. He had only been a citizen of the United States for 2 years. Well, the Democrats, as they were wont to do, challenged Hiram Revels' right to be seated in the Senate. The Senate debated it, and the Senate seated Hiram Revels anyway. They did not have to treat the Supreme Court's pronouncement in the Dred Scott decision as the supreme law of the land. They did not have to treat it as a political rule, establishing a rule for the country that has to be established in all cases, whether they come to the judiciary or not in some form. So the lesson here, I think, is that Lincoln did not purport to defy a court order merely because it was wrong on the merits. But what he did say is he didn't have to follow that erroneous decision in other judicial or non-judicial cases. He did not have to treat it as the supreme law of the land. The Supreme Court is not the Constitution. Its opinions are not the Constitution. Its opinions are not the supreme law of the land. Okay. What about ex parte Merriman? Did Lincoln defy a court order in ex parte Merriman? So who was John Merriman? Allegedly a seditionist that was blowing up rail lines in Baltimore. Well, what was the problem? Lincoln had convened an extraordinary session of Congress in 1861 in order to confront the secession and the Civil War, and the members of Congress from the North needed the railway lines in Baltimore to reach Washington. So Lincoln authorized his general, Cadwalader, to suspend the privilege of the writ of habeas corpus, which he promptly did, and he arrested and detained John Merriman on suspicion of sabotaging the railway lines in Fort McHenry without charges, without trial. Somehow he got access to counsel, though, which is very interesting because he was in a military fort. And he presented a petition for a writ of habeas corpus, which was heard by none other than Roger B. Taney, sitting as a circuit justice for the Circuit Court of Maryland. And in this decision, Taney basically held that Lincoln had violated the Constitution and had unlawfully detained Merriman because it was unlawful for the president, acting on his own authority, to suspend the writ of habeas corpus. Now, because I have a captive audience and this is interesting, was he right on the merits of this question? Some people say, was that a yes? Yes? Maybe. So the suspension clause, right, the writ of habeas, privilege of the writ of habeas corpus shall not be suspended except in cases of invasion or the public safety may require it, is in Article 1, Section 9 of the Constitution, which implies that it's a limitation on Congress's power. But I don't know, there's the, no money shall be withdrawn from the Treasury but in consequence of appropriations. Doesn't that bind the executive? So it's not obvious that it only binds Congress. And then the more radical-based argument that I would make in favor of Lincoln in this case, if you will, is Article 2 gives him the right to convene Congress on extraordinary occasions, an extraordinary session. Doesn't that imply in the Civil War at least a limited right to suspend habeas corpus along the rail lines to effectuate this right to convene an extraordinary session of Congress? Now, I will say that doesn't justify the suspension of habeas corpus, okay, that came later with respect to the draft riots. All right? But here, it's a harder question, but the general view is that Taney was right. So how is Lincoln going to get around this one? So he, of course, resorts to his good pal, again, Ed Bates, the Attorney General, who writes an opinion basically saying, yeah, it addresses the merits a little bit, but basically saying that Chief Justice Taney did not have jurisdiction because of it's a political question, he said. So what do you do when Chief Justice Taney purports to issue an opinion, a ruling, purporting to exercise jurisdiction, and the President of the United States claims you don't have jurisdiction? Who decides the question when the President and the courts disagree about jurisdiction? There is no answer to that constitutional question. That could have been a genuine constitutional crisis, which sounds kind of funny because the nation was already in a much larger constitutional crisis, right? Which is just secession and the Civil War. But might I suggest that both Taney and Lincoln approached it the right way. Cooler heads prevailed. If you actually read Taney's opinion, he doesn't command Lincoln to release Merriman. There's actually no mandate. He says, I have done everything that it is within my power to do. And I am ordering the clerk of the court to transmit this opinion to the President of the United States so he may take action thereupon. He did not order Merriman's release, and Lincoln, to his credit, released Merriman quietly anyway, despite having challenged the court's jurisdiction. By the way, does this have overtones of Kilmar Abrego Garcia, right, where the Trump administration was arguing that Judge Boasberg, I think it was, did not have jurisdiction, and then they released him anyway? Dare I say Trump was being Lincolnian when he was doing this? Okay, maybe that's a step too far, but may I suggest that that was perhaps the wise result in that case? Let me say something briefly on the merits of the question of this, is it true that Lincoln could have ignored the order if he wanted because it was made without jurisdiction? Let me suggest that the answer to that question is yes, because there's at least obvious examples where we immediately recognize that a purported order is not actually a judicial order. So suppose a district judge in the Northern District of California or Oregon, I don't know, pick up a crazy one, or the Supreme Court said, we really think Trump is exercising power unlawfully. Here is an opinion to that effect that I publish on the internet. No cases have come before me. No complaint has been filed. Does anyone doubt that the president would be able to ignore that advisory opinion That is not a genuine order, because what makes a court order is if the court genuinely had jurisdiction. There's another connection to Taney here, by the way. There's a lot of Lincoln versus Taney in this. Chief Justice Taney prepared, we have this in his letters, a draft opinion declaring the draft to be unconstitutional. And he was just waiting. He was chomping at the bit for a case to come before him where somebody would challenge the constitutionality of the draft, but no one ever brought the challenge, never published this opinion. Does anyone doubt that if he ordered the clerk to transmit this to the President of the United States, Lincoln could have just laughed it off? So it is obviously true that if a court purports to exercise power or issue opinions or orders without proper jurisdiction, then it's not actually a judicial order. And defying it would not be defying a court order. But the money really meets the road, or I guess that's the wrong expression. I'm sorry, the rubber meets the road. The money question. Where the rubber meets the road, we can just mix all sorts of metaphors that we want, is when it's actually not clear who's right about the jurisdictional question. Who gives, the court or the executive? That would be a constitutional crisis of sorts. Lincoln released Merriman, Trump released Kilmar Abrego Garcia. Let me suggest that they both exhibited a proper respect for the courts, even if they may not have had to do so in that moment. But in close questions, close calls, they properly exercised their judgment and followed what the court was exercising anyway, when it was reasonably disputable whether the courts had jurisdiction. So let me suggest in this final, shorter part of the talk that there are ways that the courts now could diminish the risk or probability of this conflict coming to a head. And I want to suggest that the district courts generally have been somewhat of a threat to the republic by exercising jurisdiction in all sorts of cases where they really did not have it. Okay? And so let me suggest something about causes of action and something about injunctions for how courts can alter what they're doing going forward to diminish this risk. Okay, the first thing I want to say is about causes of action. Do you even know what a cause of action is? I know it's silly because it seems almost foundational, but it's amazing how little it's actually talked about. A cause of action is what gives someone a right to sue. A cause of action is what says you have a legally cognizable injury. Okay? Not every schoolyard dispute is the stuff of a federal lawsuit, they used to say. Is that actually true now? I suppose many schoolyard disputes are now federal lawsuits, so maybe that's like a bad expression, but you understand the point. A mere insult isn't cause to sue someone necessarily. You need a cause of action, like tort, property, contract. Well, let me ask this. When Trump deployed the National Guard to California, to Oregon, and Illinois, what was Gavin Newsom's cause of action? What was Pritzker's? That's the right answer. That's actually correct. Let's move on. Okay, what was Pritzker's cause of action? Now, Trump did lose the National Guard case on the merits in the Supreme Court case. I don't actually care about that. My question is, who gives the right to sue in that case? Well, let me suggest how they used to do it. And there are some problems here. Some features of the legal system have changed, but I advocate in this talk, right, a more formalist conception. So let me tell you about a gentleman named Jacob Mott, which, by the way, if you listen to the podcast, you will know the story that I'm about to tell. Well, Madison called the militia during the War of 1812, and Jacob Mott thought that the militia call was unlawful and unconstitutional. So what did he do? He didn't run to a federal district judge and said, I think this is unlawful, please declare it unlawful. What he did was he refused the call, and he got court-martialed. He didn't show up to the proceedings, but he was court-martialed. He was fined. He didn't pay the fine. So the local sheriff actually, came and seized his horse in satisfaction of the debt, in satisfaction of the fine. So what happens? Jacob Mott sues the sheriff for unlawful conversion of property. This, my friends, is a judicial dispute. This is a cognizable injury. And in adjudicating that injury, the courts can adjudicate the merits of the question at hand. And if Jacob Mott was found to be meritorious, his claim, then he would be made whole. The fine would be dissolved. He would get his horse back, I guess, if you didn't sell it yet. I mean, that's a bit awkward, but you get the point. He would get damages or he'd get his horse back. The judicial power would be intact. They would interpret the Constitution and the laws for their purposes, but Madison will have still called forth the militia. No one is going to issue an injunction to stop Madison from calling forth the militia. That was an injury. What was Gavin Newsom's injury? Did he have a tort injury, a contract injury, a property injury? No, he had no cause of action whatsoever. So let me explore two possibilities. What about the APA? The Administrative, good, I'm seeing some head shakes. You're already ahead of the curve here. What about the Administrative Procedure Act? It is a widely held belief today among law professors, courts, judges, and ordinary citizens don't know anything about this, but you understand that among the people that matter for this question, that the Administrative Procedure Act creates a free-floating cause of action anytime someone is aggrieved by agency action. Let me propose to you that this is false. This is fake news, you might say. The APA does not create a cause of action. To the students in administrative law, do not put this on your exams, by the way. Like, I don't want you to get failing grades. But the APA does not create a free-floating cause of action for anybody within the zone of interests of the statute. What the APA says is judicial review shall be had anytime someone has a legal injury, which implies an existing cause of action, or if someone is adversely affected or aggrieved within the meaning of the relevant statute, which means the statute itself in question, not the APA, but some other statute that is being violated, must itself create the cause of action. So this doesn't actually help Gavin Newsom. By the way, even if the zone of interest test did apply, like, would it apply to Gavin Newsom? Like, is he within the zone of interest intended to be protected by the National Guard statute? I don't know. But the point is, I doubt it. But either way, this is all made up. The APA does not create a cause of action. The statute itself did not create a cause of action. Okay, now here Professor Green and I might disagree, but I don't know. What about ex parte Young? What about ultra-virus actions? Is there this free-floating cause of action to challenge the unlawfulness or unconstitutionality of government action? I don't have time to defend this proposition, but let me suggest to you that ex parte Young is totally historically incorrect. It is totally historically incorrect. You don't have to go, however, as far as me for that. At best, certainly in my view, that's what I used to say, but now I could say in the Supreme Court's view, ex parte Young, these anticipatory injunctions, at best, what John Harrison has called an anti-suit injunction. In other words, if there is some threat of if you are enforced against, the government comes after you, and you could defend by saying the action is unconstitutional or unlawful. You could, instead of waiting to be enforced against, you could file an anticipatory action where instead of raising this claim as a defense, it's an affirmative claim. This is what we call an anti-suit injunction. The Supreme Court has adopted the Harrisonian view of this question in Acosta footnote. Okay, footnote 7, do you remember footnote? I think it was footnote 7 in the Acosta case. So let's just go with that. The Supreme Court has said I'm right about this and John Harrison is right, so let's go with that. Does this help Gavin Newsom? I don't see how it does. Was he threatened with some enforcement action? Not at all. Gavin Newsom, even under this anti-suit injunction, did not have a proper cause of action. Does this mean nobody could sue? Does this mean nobody could sue? Oh, a National Guardsman could refuse the call. Okay, that's probably not going to happen. What if a National Guardsman committed a trespass or was ordered to seize somebody? That person can then sue the guardsman for false imprisonment. Then you have a cause of action. And then the National Guardsman would defend that I had these orders, and then the plaintiff would say, well, your orders are invalid. And if the plaintiff is correct, then the plaintiff will be made whole for the injury. The courts will assess the validity, the constitutionality of the National Guard deployment in a particular case or controversy where someone has a legitimate, legally cognizable injury, which the president can then ignore with respect to everybody else. He could continue to deploy the National Guard and just say, be very careful before you trespass on someone's house or seize somebody. The courts, might I suggest, would properly be exercising their judicial role, their judicial duty, their judicial power, but the president would still get to be commander-in-chief. Okay. How am I doing? Okay, not great. So, in the last, I'm going to shorten this. So in the last 2 minutes or so, let me say something about injunctions, which is anyway more familiar to you, so I'll be brief about this point. Even if there is a cause of action, there's this question about remedies and whether an injunction against the president or the administrative state is the appropriate remedy. So let me suggest the first thing you have to remember is that remedies at law, if those are adequate, injunctions are inappropriate. There is a reason that Myers, Humphrey's executor, the Wiener case, they were all suits for salary when the officer was removed. If a salary is available in the Court of Claims, that seems like an adequate remedy to me. So what is the deal with all of these district judges ordering reinstatement of fired employees or filed officers? At least consider whether the remedy at law is adequate or not. The second thing I want to say, why do they always have to be pre-enforcement injunctions? Dare I say that sometimes these cases will be fact-dependent? Take the birthright citizenship case, for example. Now, if you take the view that I have taken on this and published about this, then the answer might be different for unlawfully present aliens than it is for temporary sojourners. There's actually 3 different views of the question with respect to temporary sojourners. Let me give you an example of one view, which I don't think is right, but it's a view that was available. Some people said, including secretaries of state, shortly after the adoption of the 14th Amendment, that if a child is born to a temporary visitor, some said they're not a citizen at all. Others said that this child, if taken back to the home country, could come back to the United States soon after reaching the age of majority, within a reasonable time of reaching the age of majority, could renounce his parent's citizenship, and could elect U.S. citizenship. Let me propose to you that a pre-enforcement injunction, a pre-enforcement posture, how will the Supreme Court ever possibly consider this evidence and this possibility in a case involving unlawfully present aliens, temporary visitors, those who did go back to the home country, those who didn't, those who came back after going? How is it possible to even address this possibility? Dare I say that by accepting this case in a pre-enforcement posture, the Supreme Court has actually invited a resolution that would apply to all of these cases, which stacks the deck, I think, against the government's position here. So why do these cases always have to be pre-enforcement? And finally, the universal injunctions case, the Cossack case, obviously correct in my view. Injunctions can only bind the parties to the case. This is just going back to Dred Scott. It's Lincoln versus Douglas. Let me suggest 2 further points here to be a little polemical. Not polemical, I actually believe this. The CASA rule applies to the Supreme Court itself. In the oral argument, Sauer said, no, we will treat your decisions as law. That goes way beyond what Lincoln did. So it applies to the Supreme Court itself. And let me finally suggest that class actions are not actually a substitute for this. Now here, I'll invoke Justice Holmes, who said a page of history is worth a volume of logic. There were class actions and bills of peace during the New Deal, and yet no one thought to use them against the Agricultural Adjustment Act and the National Recovery. Instead, you had 3,000 some injunctions by various judges in individual cases. So let me suggest that no one until today thought class actions would be suitable in cases respecting ultra-virus government action, and so that is not a replacement. Okay, let me stop here and just suggest sort of in semi-conclusion, actually in just conclusion, that I don't think we're in a constitutional crisis. I don't. I actually think Trump and the executive branch have shown pretty good restraint in light of, in my view, district judges purporting to exercise jurisdiction in many cases where I really don't think that they had it. So let me suggest that if there is a greater threat to the republic, it probably is coming from the district courts today. So that's the polemical thing I will stop with, and I look forward to Jonathan agreeing with everything I've said. So thank you.
Professor Green.
All right. Well, good to see you all again. Sorry you're getting me twice today, but I'm grateful to be here, not least to be able to see my old friend Ilan again. So that was all really interesting and helpful. I guess I will just throw out a few questions for follow-up, and then maybe we can open it up to you guys for questions for Professor Wurman as well. So the first question I had goes to the title of this event. So you suggested that district court judges, to the extent that they are overstepping or placing the relation between the courts and the executive branch in pushing that relationship into potentially dangerous waters, could be restrained by something called formalism. And I would love to know what that is. I think a lot in my scholarship and some of the students that are here that are in my statutory interpretation class think a lot about what formalism is and how I would know if I'm a judge whether or not I am acting within the forms that the law has provided. And it strikes me that at least some of the district court judges that I imagine Ilan disagrees with just take a different view on what the law requires of them in some of these cases. No, there are obviously instances where judges are overreaching and I think are making decisions that don't really have a credible or plausible basis in any reading of the relevant statutes. But there are other cases where I think good faith judges are doing their best to exercise the jurisdiction that's been conferred on them and are enjoining various actions of the executive branch, some of which I think are pretty obviously unlawful. And that seems to me like exactly what a district court judge should do when faced with a suit over which it has jurisdiction and where there's a party withstanding who's complaining about unlawful government action. So that's the first question. What is formalism? The second is...
I'll write them down. I'll add them up. Okay.
Great.
What is formalism?
Second question, and I guess this is less of a question and more of just a point of agreement. I mean, I do think that there are pretty obvious places, both historically and just conceptually, where you could see the Constitution short circuit. One of those would be a dispute between the executive branch and the judiciary over a decision, or over a dispute not simply over the merits of a high-profile or politically charged issue, but over the underlying question of jurisdiction. I think you're right that it's not clear whose view on the jurisdictional question trumps in a situation like that. I mean, this is in effect the precipitating sort of pattern for the Civil War in the 19th century, and it's not just in this country.
Give us the German history.
Judge Holmes mentioned that I spent a little bit of time thinking about German history, but this is exactly the same problem that comes up in the German Confederation in the run-up to German unification, is this question about if you have a federal system of disaggregated sovereignty, at the end of the day, there's this kind of Schmittian question of who decides on the scope of the powers that have been delegated to a central government and the residual powers that have been retained by the constituent member states. You can set out those boundaries as clearly as you like, but at the end of the day, you need someone with final authority to decide on the interpretation of those delegated authorities. And Ilan might be suggesting something like a clash not at the vertical level, a dispute between the federal center and the states, but rather something like a horizontal clash between the judiciary and the executive branch on the scope of powers that have been delegated to each of those branches of government. Ilan preempted the point that I was going to make along these lines just there at the very end of your remarks, but it does strike me that in CASA, the Solicitor General, speaking on behalf of the government, represented that at least this administration would comply not simply with orders of the federal courts in cases where they had jurisdiction, but the executive branch would also give, I can't remember the exact language that Sauer used, but due deference or would respect the precedential force of the decisions of the United States Supreme Court. And I wonder if you think that stops the executive branch from disagreeing on the merits with decisions of the Supreme Court that it might disagree with going forward. I think you're right that, so the most high-profile case that the Trump administration has lost so far is the tariffs decision, and we haven't seen any kind of signs that the executive branch is looking to openly defy that order. It's looking for legal workarounds, which I think is a really healthy sign. But I wonder, as a political matter, if not a legal matter, whether that representation by the Trump administration to the court should factor into this analysis. Well, yeah, maybe I'll stop there and let Ilan talk. Those are a number of questions, and then would be curious to hear from all of you as well.
The nice thing about there are some There are some conferences that I go to. I think you may have been as well, where there's a rule of three, where you take 3 questions from 3 different people, and the rule is, if you're the speaker, that allows you to decide which ones you want to answer and which ones you want to dodge. I don't think that's what Professor Green was aiming for here, but...
I wrote my questions down, so you're not getting out of them.
Okay. So I'm going to do one bit of shameless plugging to answer the formalism question, and I guess I'm okay with the shameless plug because we aren't paid to be here. I mean, they pay the flights, which is nice. So let me tell you about this book that the judge suggested is coming out, The Constitution of 1789, A New Introduction. It's coming. The subtitle really should be All the Lies Your Con Law Professors Taught You, and so it is intended for law students, lawyers, general readers who have never experienced, an originalist, textualist, formalist, conservative interpretation or argument about the various provisions of the Constitution. And actually, a chunk of my talk comes from the books on judicial power and Dred Scott and slavery and departmentalism. But I have a whole chapter that answers this formalism question. And so I hope you will check that out, because the answer that I'm about to give is necessarily going to be abbreviated. And there's a lot going on that you could find in the book as well, which, yes, is available for pre-order, by the way. It should come out before the semi-quincentennial. That's the idea. But my publisher is British, and so they might. I don't know how. Do they have? I don't know if they're still upset about that at all. But I'm hoping it comes out in time for July 4. But so the formalism question, which is true, is in the title, and I didn't answer it. So let me suggest that answer it in the following way, and it's not going to be a complete answer, but formalism does not have a necessary connection to functionalism. Formalism does not have a necessary connection to originalism. Okay? Formalism, as a general matter, stands for the proposition that the law prefers, or we prefer in the law, clear legal rules, including fictional ones. If they're fictional ones, that's fine, as long as they're clear, and nevertheless, the clarity of the rules do some work. So let me suggest to you that Humphrey's executor, this case approving an independent administrative state that identified quasi-legislative, quasi-judicial powers, was actually formalist. Or it was not inconsistent with formalism, because there's nothing about formalism that compels the conclusion that there are only 3 types of power, right? Maybe there are 5 types of power. Maybe there's legislative power, executive power, judicial power, and maybe there's quasi-legislative power and quasi-judicial power. As long as there's a way to figure out what the different categories are, that is not necessarily inconsistent with formalism. I will say that in separation of powers disputes, formalism and originalism do tend to go hand in hand. We disagree as originalists with Humphrey's executor, not because it's not formalist, but because it's just dead wrong on the original meaning of the Constitution, okay? So in the separation of powers cases, a formalist or formalism stands for the proposition that the Constitution recognizes only 3 types of power: legislative, executive, and judicial, and the exercise of those powers must comport with the constitutional strictures for each branch. So if it's legislative power, it must be done by Congress through bicameralism and presentment to the president. If it's executive power, the president must have, well, that's the question in Trump v. Slaughter, right? Whatever executive power says about that, right? And then if it's judicial power, it must be exercised by courts with lifetime tenure and salary protection. Let me say, I said I was going to abbreviate the answer, but I'm already going, so I'm going to say this next thing too. It doesn't follow that all government functions are only one type or another. Some things the government can do, in fact, many things, could be done through Congress exercising its legislative power, or through the president exercising his executive power, or maybe through the courts. So let me give you an example. This you should put on your administrative law exam. I don't know how far it'll get you, but I certainly expect my students to talk about this if appropriate. One of the earliest statutes assumed the payments of the Confederation Congress had made to the invalid veterans of the Revolutionary War under such regulations as the President of the United States may direct. And we have Washington and Henry Knox's regulation that says show up at these 2 times, 3 months apart. Here are the proofs that you need to bring, and if you are a power of attorney, if you need to bring that. Could Congress have enacted that regulation as part of its legislative power through an exercise of legislative power? Of course it could have. Of course Congress could have legislated that specifically if it wanted to. Does it follow that the president cannot do the exact same thing pursuant to a delegation of authority from Congress? Or does that delegation make it an exercise of executive power? So when I say formalism stands for the proposition that there are three types of power, it doesn't mean that the same result cannot be achieved through different branches exercising those three types of power. Okay, let me bring it back to this particular debate. The question here is simply, what is judicial power? And judicial power is not the power to say what the law is. Actually, can we get the Federalist Society motto revised after this? They say, is emphatically the, what do they say? Emphatically the province and duty of the judiciary to say what the law is. Can we revise and extend that in cases and controversies properly before them? Because actually, there's a lot of people who just say, oh yeah, it is, even if you agree with that statement. They say, oh yeah, the judiciary says what the law is. Well, so does the president when he has to decide what the laws require of him. Congress has to interpret the Constitution when they decide whether they can seat or not seat somebody, or when they're passing some law, they also have to interpret the Constitution. So that is what I think so it is not, so is all of this necessarily formalist? Well, it doesn't have to be. It is originalist in this case. So really the title should have been, and I didn't think of it in advance, but I didn't think you'd ask me such hard, actually you knew you would ask me hard questions. Didn't think you'd ask me this one. Really, it's a formalist and originalist conception is what I'm advocating for. Not just like formalism as such, which could apply in contract law and civil procedure and other areas of law as well. So let me say that. On the need for final authority, this idea that sovereignty is always conserved, and sovereignty is the power to have final say over questions of power. Let me just suggest in the American system, the sovereignty rests with the people. And at the end of the day, there's no constitutional answer to the question of who gets to decide if the president or the courts disagree, right? And so they could fight about this, and eventually it's up to the people in the political process to make some decision. But let me suggest, and now my podcast co-host is really gonna squirm, like what is law, if you listen to that episode. She thinks law is threats backed by force. And international law is fake and dumb, I think is what she said at the podcast. And I think law can come from customary emergent practices of the people over time. It's what we might recognize as law pursuant to some rule of recognition. Well, let me suggest that from Lincoln to Trump, the two of them have created a constitutional custom of respecting the court's assertions of jurisdiction in cases where jurisdiction is reasonably debatable. And so maybe that's a custom now, like I think Taney didn't have jurisdiction, I think Boasberg didn't have jurisdiction, but you know, unless it's a clear case, I'm gonna respect the courts. Maybe that's law, because Trump felt himself bound by that, and Lincoln felt himself bound by that. There's no threat backed by force there, but maybe that's still law, and maybe that answers this question. Did Sauer stop himself? Practically, yes, but I don't care. Like, I care what the answer is, right? I don't care how to win at the Supreme Court. But he was absolutely right to make that concession to the Supreme Court, because then he would have lost all the judicial supremacists on the court. And they're all judicial supremacists, aren't they? But you would be too if you were on the Supreme Court. Sorry that I filibustered.
Professor Green.
Or questions, totally up to you.
Yeah, so maybe this follows up on something you were just saying. So it does strike me that the decisions of the Supreme Courts and federal courts of appeals bind actors other than parties to those disputes within Article 3, given the law of stare decisis that's emerged historically over time. And that doesn't come from any formal source of law, like a statute, or, Justice Kavanaugh has suggested in a few different places, maybe it's implied by the concept of judicial power in Article 3. That seems to me historically implausible, given that much of our system of stare decisis was not present in the 18th century. But maybe the system, the system of rules that we have about the circumstances in which one decision by the Supreme Court, for instance, binds later justices on the Supreme Court, the hard and fast rule we have that generally speaking decisions of the Supreme Court bind all lower federal courts. There's some uncertainty right now about the exact precedential status of orders on the court's shadow docket or emergency docket or whatever else you want to call it. Right?
But stop crazy judges from doing crazy things docket? Okay, sorry, you don't have to answer. Continue.
continuing. You know, I wonder whether or not there might be historically a norm that, absent some kind of extraordinary circumstances, the executive branch generally acquiesces in the federal court's assertions of jurisdiction over a particular case or controversy. I mean, there are all kinds of places where, in my kind of capacity as a Civ Pro professor, I think the Supreme Court has misunderstood the doctrines of personal jurisdiction, for instance, or doctrines of federal question jurisdiction. I think the gun Minton line of cases are basically made up for some of the reasons that the gun v. Minton line of cases about assertions of federal question jurisdiction where the cause of action is, the underlying cause of action is state law. That just like makes no sense to me. It seems like basically a category of cases that the Supreme Court would really quite like federal courts to hear, even though they don't have jurisdiction over those cases. And so they've invented this new doctrine that somehow confers that kind of jurisdiction on them. Anyway, all that to say, for understandable prudential reasons, the executive branch at the federal level and the states, I think for the most part, at least over the last few generations, have acquiesced in the federal court's conclusions as to the court's own jurisdiction. And I wonder how I would know whether that custom has become a legal rule akin to the rule of stare decisis within the judicial branch. And if so, maybe there's something more to Sauer's concession than kind of strategic posturing before a bunch of judicial supremacists on the United States Supreme Court. What do you think?
Great, thank you everyone for coming. We're out of time. No, okay. So I guess I would say a few things to this excellent and difficult question. Lincoln did say something interesting in his debate with Douglas. He said, you know, that it doesn't mean you should follow, just because I don't want to disturb the judgment, doesn't mean you have to follow what the court said the law is or the Constitution is as a political rule, unless, I left this part out, because I was hoping no one would ask me about it, unless it has been established through a series of decisions and the people and the states can be said to have acquiesced in the question, right? It would be, he said, revolutionary to unsettle something like that has been acquiesced in. This is very similar over a long time. And basically, that can establish a political rule. Acquiescence can establish this political rule that should be followed. This is very similar to James Madison's theory of liquidation, where it's not a single decision of the Supreme Court or a district judge, certainly, that establishes the definitive meaning of the Constitution, but within the range of ambiguous meaning, within the range of possible meanings, over time, the answer could be settled within that range, not through a single decision of the Supreme Court, but through a general acquiescence of the political branches and the states and the people. How is that reflected? Madison thought it was reflected in the bank debate over, which he had opposed the bank in 1791 and then refused to veto the next bank because he said this has sort of been a settled a question. And so it is possible, but let me suggest that it has to be this theory of acquiescence and liquidation must still be within the range of possible original meanings. I just don't, look, I just can't quite get there in terms of you could have a theory of law that we the people recognize as legitimate, a long-standing course of practice, even if it violates the Constitution that the people adopted before. Maybe this liquidation is a kind of rule of change. I think that would be inconsistent with the Constitution, which provides its own rule of change. Does it follow we couldn't have a system in which we supplement the Constitution's rule of change in this way? We could, maybe we do. I don't think we do, because even when it comes to acquiescence in these discussions, they argue that it's like, look, I'm not going to go with what I would have done. I'm not going to go with what I think the best meaning was if I were there 100 years ago deciding this question for the first time. That is very different from saying, well, this usurpation has been acquiesced in. A usurpation is still a usurpation. And so you could have that theory of acquiescence that goes beyond the scope of possible meanings, but that means something other than the Constitution is creating the constitutional rule in question. And that could be a rule of, there could be a rule of recognition that says that that's okay, that the Constitution gives us 99% of our constitutional content, but there's a 1% outside of it. But it would not be the Constitution creating that rule. And so when it comes to district court or Supreme Court judges exercising jurisdiction in these questionable cases, I guess the question would be if you think that that is within the possible understanding of judicial power, and I would suggest that there really must be jurisdiction, and I don't think there is a settled rule as to what happens when the executive and the courts disagree on that question. So I certainly don't think there has been an acquiescence there, though, as I said, if there is any practice at all, it's Lincoln and Trump releasing Kilmar and John Merriman. So we get something there at least.
Well, we've settled that President Trump is Lincoln-esque, so that's one good thing from this debate.
At least as good as Lincoln. What does he say?
We have a couple minutes. We have time for at least one question if anybody wants one. I see a raised hand in the center there. Go ahead.
And we'll see if we can take both.
That's you, the one looking to either side. Go ahead.
Yeah, wait for the box. It's on its way to you. This is better than yesterday where they tried tossing it.
Close enough. We can hear you.
Okay, great. I'll project. Absolutely. Professor, on your class action point, I'm going to take you to be right about the history of the New Deal cases. The problem I think you have is that Rule 23b2 was added in 1966, and the advisory committee notes sure seem to think that it's going to apply to ultra-virus actions by governments. What do you do with that?
I said we are out of time, right? So I don't think the federal rules of civil procedure can alter substantive rights, and I don't think they can expand the scope of the judicial power. I don't want to have that fight with people right now. But that is my gut reaction or initial reaction, having studied this issue only a little bit, but not having run down all the way to the rabbit hole. But that would be my first level response. Now, would that be an expansion of judicial power? Well, yes, if you think I am right about everything else I have said.
Professor Green.
So, very good question. Yeah, maybe you actually. He's a civil procedure person. My goodness. Yeah. When you said professor, you were ambiguous. Did you
Great question. You know, I mean, I guess part of what your question makes me think of is it goes to the same question that the court was thinking through in CASA about the scope of equity. Group actions like the class action were traditionally brought in equity, not at law, in the really across the 18th and the 19th and even into the early 20th century in most states. And so the question, to the extent that we're willing to concede that the amendments to the class action rules in the 60s were an expansion of the equitable jurisdiction of the courts, then it goes to this question, okay, well, how flexible is equity and how much can equity evolve over time? CASA suggests that maybe the answer is not so much. I'm kind of skeptical. So I agree with Professor Wurman that the decision in the CASA case was right. But the kind of underlying question about how much sort of given the joints of equity is there is one that I think that the court kind of skated over to a large extent in CASA. But I think that's exactly the right question to be thinking about in the context of the very good point you raised. So.
Good. Thank you for that. One more.
We had one right here.
Okay, over there on my right. Yes, go down a
you're
couple
just
steps,
gonna project.
microphone guy.
Let me circle back. You said you're an undergraduate at Georgetown? Okay, that was an insanely intelligent question. For the listeners online, for posterity, there was no microphone. The question is effectively that this whole theory of judicial power and giving damages and remedies in these cases requires the ability to sue officers for having violated the law and recovering damages. And this is perfectly consistent with a case, Little against Barem, where Captain Little of the Flying Fish was ordered by John Adams to do something that the statute did not allow, and Chief Justice Marshall agonized over it and said, my first impression was that surely he can't be made liable, and then on further reflection, yes, he is liable for damages, and the remedy for him is from an indemnity from the legislature. And so in my view, this is going to get me in a lot of trouble, but what? I have tenure and a podcast now, so I get to say whatever I want. All those cases providing or abolishing causes of action against federal officers, all of those cases providing immunity for federal officers, I do not think Congress has the power to do that on the necessary and proper clause, because that would be too great and substantive a power to be left to implication. And so, yes, the Westfall Act is unconstitutional. Thank you.
Whoa.
I said I would be controversial at least once.
There we go. Well, we have reached 4:03 p.m., and I don't want to intrude or trespass on the next panel, for which there would be no adequate remedy at law. So let me join the audience in thanking you, Professor Wurman and Professor Green.